Hi, this is Stuart Talley. I'm here to provide an update on the ongoing Pinnacle metal-on-metal hip litigation that is currently being litigated right now in Dallas, Texas. If you've been following my updates, you know that there was recently a verdict in a case on behalf of 5 plaintiffs for a combined value of about $500 million. Since that verdict, which was a couple months ago, there have been a series of what we call post-trial motions that were filed by the defendants to have the verdict overturned and to request a new trial. And so today I wanted to sort of go over those motions and discuss them. The first one, which I think is one that is probably the most important in the litigation, is a motion by the defendants to limit the punitive damages that the plaintiffs shall receive. The verdict in the case, and the jury awarded punitive damages, and those are damages that are intended to punish the defendants for their conduct. The award was $360 million combined for the 5 plaintiffs. Unfortunately, Texas has a very strict law that limits punitive damages, and all of the plaintiffs in this case were from Texas, so that Texas cap on punitive damages applies to their case. The formula for capping those punitive damages is a little complicated. It's based on what your economic damages are, and the award cannot exceed 2 times your economic damages, and they cannot exceed your what we call general damages, pain and suffering damages, and there's a cap of $750,000 on those types of damages. So you add the 2 times economics plus the $750,000, which applies in most of these cases, and that's what you end up with. So the net result of all of this is that the $360 million punitive damage award will likely be reduced to $8.6 million, which in the context of Johnson & Johnson and DePuy, a punitive damage award that low really will have no impact at all on their corporate behavior, which is the intent of a punitive damage award. It's to punish a defendant. These companies combined have a net worth of more than $68 billion. So $8 million is a very, very small number for them. On the bright side, we have another round of trials coming up. The next group of trials will be for 5 plaintiffs, and the judge has asked for 5 plaintiffs who are from California, and those cases are currently being worked up and they're in the system, and that will be the next group of cases to go to trial. California has no caps on punitive damages, so these caps that applied in the most recent verdict will not apply in the next case. The second motion that was filed is the defendants argued that the jury verdict should be overturned on the grounds of the statute of limitations. The statute of limitations is the time period in which you have to bring a case. In Texas, it's 2 years. What's galling about the argument being made by DePuy and Johnson & Johnson here is that in all of these HIP litigations that have been pending, the ASR litigation, the Pinnacle litigation, they have consistently taken the position on the issue of settlement that they would never settle a case if the person did not have a revision surgery. But now they're telling the court that in order for you to bring a claim, that you have to bring it within 2 years of the date that you first started experiencing pain with your hip. So they're arguing that the trigger date for the statute of limitations is not the date that you had revision surgery, it's the date that you first had any symptoms at all that your hip was failing. The jury in the case found that that wasn't the start date for the statute of limitations, that the start date was the date that they had the revision. Now the law in Texas is very good for us on this issue. In order for a cause of action to accrue, you have to be aware of your injury and you have to be aware of the cause of the injury. And there was lots of evidence given in the case that the fact that somebody's hip hurts doesn't necessarily mean that the defect with the DePuy Pinnacle hip is what's causing your hip to hurt. There are all kinds of reasons a prosthetic hip can cause pain that have nothing to do with shedding of cobalt and chromium. It could have been implanted incorrectly. There could be a leg length discrepancy. The person could have tendonitis. There are a whole bunch of reasons why a hip can hurt that have nothing to do with metallosis. And in most of these cases, a definitive diagnosis of a failed metal hip doesn't occur until the surgeon actually goes inside and looks and sees what the hip is doing. So that's that motion. I'm not too worried about that one. The other motion they filed was they wanted a new trial because the jury was not instructed on a very specific Texas statute that basically gives the defendants a presumption that their product is not defective if the product is approved by the FDA and the defendant can show that the FDA was given all of the information about the product before it approved it, all of the relevant information. The opposition to that motion was that, first of all, these hips were never approved by the FDA. The word approved has a very specific legal meaning. There are some products that are approved by the FDA. The FDA requires clinical testing. They require a whole bunch of tests. It's a very long process called the pre-market approval process. And the FDA will actually look at these tests, look at the design, and decide that the product is not defective and release it and allow it to be released to the public. The Pinnacle metal-on-metal hips were not approved through that process. They were approved through a process called the fast track process. And that's where a manufacturer basically tells the FDA that the product is substantially similar to something else they already approved. And that's how this product got on the market. In the past, the judge has indicated in other motions that this fast track process of getting a medical device on the market is not FDA approval. So that presumption does not apply, and I think that is a sound judgment that the judge made that is well supported by the case law that has specifically looked at this issue. The other thing that, or sort of the last motion that they brought, was a motion for new trial that had different grounds in it. The first one was that the jury verdict was too high. The argument is that it was a runaway jury. There's no way that the damages that these plaintiffs suffered support a verdict that is as high as they received. The standard for overturning a jury verdict or reducing a jury verdict in Texas is very, very high. You have to show that the jury was biased, that they were motivated by passion. It has to be a situation that almost shocks the conscience. I don't think that the judge is going to reduce the verdicts in this case, other than the punitive damage verdicts. The second argument that was made in this motion was that the defendants were very unhappy with the fact that 5 cases were able to be tried in one trial. They thought that that was unfair, that it caused jury confusion, that it influenced the jury because there were 5 people sitting there, all who had suffered similar injuries. And so the standard on that issue also is good for the plaintiffs. The judge has a lot of discretion, especially in a case like this where there are thousands of lawsuits pending, all involving the same product. The judge has discretion to implement mechanisms to make the process go faster. He has the discretion to implement processes so that there's what we call judicial economy. Trying thousands of these cases could clog the courthouses in this country for years and years. And so by trying 5 at a time, it saves everybody money. It saves the plaintiff's money, the defendant's money, and it saves the court system time and money. So I don't think that argument is very well taken. The motions filed DePuy also had numerous pieces of evidence that were admitted during the trial that they thought should not have been admitted, and they want a new trial because of that. Specifically, there was references to something called the Deferred Prosecution Agreement. This was an agreement that DePuy entered because they were paying bribes to doctors. That was admitted into evidence. There was reference to cobalt and chromium potentially increasing the risk of cancer. That was something that was brought up during the trial as a reason why somebody would want to have their hip removed or revised if they had high cobalt or chromium. And the argument there was that somebody with high cobalt and chromium, it would be reasonable for them to want to have their hip removed just because of the fear or the risk that high cobalt and chromium could increase your risk of cancer. There is no studies showing that it does, but that doesn't mean it doesn't increase the risk of cancer. There was argument at trial or evidence presented concerning the fact that there were thousands of lawsuits that have been filed against DePuy. There was reference to the DePuy ASR hip, which is a hip that's very similar to the Pinnacle that was recalled. So all of these small evidentiary issues the defendants had a problem with, and they've asked the judge for a new trial. The argument that they make is that these pieces of evidence, by being admitted and presented to the jury, bias the jury against them. The judge, in prior motions during the middle of the trial, has already ruled that none of these pieces of evidence that were admitted improperly, and denied the defendant's motions already on numerous occasions concerning each one of these items. So I don't expect the judge to change his mind on those issues. So those are the issues that are out there right now. The other thing that has happened is the defendant has filed a motion to stay the litigation, the overall litigation. So they are asking the judge to not let any more cases go to trial until the appeal of this verdict works its way through the appellate court system. If that motion is granted, that would put thousands of cases on hold for probably 3 to 4 years. Nothing would happen. Settlement would be very unlikely to occur during that time period. It is highly unlikely that the judge is going to grant that motion because it really would put a screeching halt to the litigation. And in fact, the signals we are getting from the judge is that he is moving the other direction. He wants another round of 5 cases to go to trial. So that's where we are in the cases. When we get orders from the judge on these motions, we'll do another video. We'll try to keep you updated on the appellate process and how that's progressing. But things are moving along. We all wish they would move quicker, but that's the process. It takes time. If you have any questions or comments about the litigation, what's going on, feel free to give us a call. You can reach us at the phone number on the screen, or you can fill out one of our online forms and a lawyer will call you right back.